Hello, PBL 200 students. This is a talk through of the recent test. So this is the 2018 October test where you got a question on the Harkson versus Lane test. For future years, this will be a teaching reference as well for students to see how we mark this question in 2018. Here was the question. Question 3 in the October 2018 paper. Two questions for Harkson versus Lane for the test 3.1, where you had to argue in favor of the complainant that the firm discriminated against the young student, the young applicant, and then in 3.2 you had to argue in favor of the firm that the discrimination was fair. In both these cases you refer to Harkson versus Lane, and the entire question was marked in half marks. So the 4-mark question for 3.1, that would have been any 8 items or arguments or facts, and 3.2, a 3-mark question, any 6 arguments or items that you had to refer to. In the 2018 year, for the test, or when I marked these questions, many students did not answer it very carefully, and often students dealt with matters relating to fairness and unfairness, already dealt with that in 3.1. I marked all of those as if the student answered it under 3.2, but strictly speaking, I should have ignored it if it was under the wrong heading. 3.1 only wants to know whether the firm discriminated. 3.2 only wants to know if the discrimination was fair. So in other words, for 3.2, no issue to argue around whether there was discrimination or differentiation. 3.2 makes it clear there is discrimination. The argument that the student had to write here was to say that the discrimination was fair. And in 3.1, the only issue to determine was whether, or that you had to argue that there was discrimination. So not to mention anything around differentiation, only to discuss why these facts amounted to discrimination. Now, as I said in class, the way to answer these kinds of problem-based questions, start with the authority. Start with the authority and the principles, and then apply these principles to the specific facts. These questions will always be novel, so you'll have a number of problem-based questions and examples in class and tutorials. The test and the exam will always have a new problem, where there will be a substantial number of marks for the application of the principles. So as I said then, in class, start with the principles and the authority for the principles. So 3.1, if we start here, where you had to argue that the firm discriminated against the young applicant for the position. So start with the principle and the authority for the principle. Section 9.4 of the Constitution prohibits private unfair discrimination. 9.3 would have been wrong. 9.3 refers to the state. This was a private law firm. So 9.3 has no relation to a private law firm. It's 9.4 is the correct section to reference. 9.4 prohibits private unfair discrimination. What is discrimination then? Many students miss this definition completely, didn't mention it in the answer, and then everything after that is difficult to follow the argument because the starting point has to be the definition. What is discrimination? It's differentiation based on a prohibited ground. So the rest of the answer had to unpack these two phrases. Where was the differentiation, and where was and which prohibited ground or grounds were in play? So the first point would have been that the differentiation is between someone who fits with the firm's look and feel, whatever that may mean, we'll get to that, and someone who does not. Similar to the next one, the differentiation is also between a candidate who owns a car and another candidate who does not own a car, and the third one where someone has a driver's license and someone else does not. So there were three, if you want to refer to in and out groups, three in groups created, three out groups created. So the answer really should have been the starting point. Where does the differentiation lie? Which three groups are being created? Look and feel, own a car, has a driver's license or not. So that really should have been explicitly mentioned in the answer. Where is the differentiation? Which groups are being created? And then which prohibited grounds? Now in this case there's not explicitly none of the listed grounds in section 9.3, none of those grounds are explicitly implicated here. Look and feel, or if you want physical appearance, is not mentioned in 9.3. Owning a car is not mentioned in 9.3. Owning a driver's license is not mentioned in 9.3. So this could only be either an unlisted ground where there's a separate test for the recognition of further prohibited grounds. It's either another further prohibited ground, or this could have been indirect discrimination on a ground listed in section 9.3. So if you want to go the route to say that these new grounds, physical appearance, now again it can't be, the ground cannot be status as car owner or status as driver's license holder. What's at play here, and most students pick this up, is socioeconomic status or poverty. The ability to own a car is directly linked to your socioeconomic status. The test for the recognition of further prohibited grounds is if such grounds have the potential to infringe the complainant's dignity. Most students had that, but then they did not apply that test to the new grounds to be recognized. So if you want to argue that physical appearance should be recognized as a new prohibited ground, then you had to apply that test. Why would, if you are discriminated against based on your physical appearance, why would that infringe your dignity? Same with socioeconomic status. If you are discriminated against based on socioeconomic status, why would that infringe your dignity? The argument around a driver's license is a bit different, because it's not as serious as not being able to own a car. You can obtain a driver's license without having your own car. So it's debatable whether the same issues apply with the same force to not having a driver's license. All right. 3.2. The argument, or again, you only had to argue that the discrimination was fair. You had no choice here. You had to argue that it was fair. Again, start with the principles and the authority for the principles. Harkson versus Lane lists a number of factors that a court should always take into account in working out whether discrimination was fair or not. The impact of the discrimination, the position of the complainant in South African society, the nature of the discrimination, the purpose of the discrimination. That would already have given you 2 of the 3 marks, just if you simply listed the 4 factors. Many students only wrote down the purpose of the discrimination and ignored the other 3. It is not a cherry-picking exercise where you can only look at 1 or 2 of these factors. You have to consider the cumulative effect of all of these factors combined. So in the answer, you should really have dealt with all 4 of these, making an argument in the end that the cumulative effect of these factors would have led to fair discrimination. The impact of the discrimination, if you are arguing in favor of the firm, you would have to try and indicate why the impact was not as severe on the young applicant for the position. You could, for example, say that he is a young graduate, he has a degree already, he has good job prospects. It's not as if this is an economic death sentence. If he doesn't get this job, that he won't find any other employment ever. The position of the complainant in South African society, again, he has a degree. He may well be a member of a previously disadvantaged group in South African society, but you may argue in favor of the firm that he is a privileged member of society in that he has a degree and has good job prospects. The purpose of the discrimination is the strongest one to work with. There is a clear link between at least having a driver's license The owning a car is a debatable issue, but at least that if he has a driver's license and where he has to do a lot of traveling for the firm, that is a strong indication of the fairness of the discrimination. Now again, how this will play out in a real trial is something else. For this question, you had to argue that it was fair. Whether you personally believed that what was done to this young student was unfair, that is something else. That's a class debate or a separate discussion. But for this test, you unfortunately had no choice. You had to argue that it was fair. So you had to work with these four factors as best you could to indicate that the discrimination was fair. I hope this short discussion helped you a bit in unpacking the memorandum for question 3 in the PBL 200 question for 2018. Thank you.